Hello students, today I am going to teach Corporate Administration Chapter 1 in Introduction to Company. 10 marks or 4 marks questions. Let us see the second question. Already I have uploaded the first question and this one is the second question. State the highlights of Companies Act 2013. When the Companies Act 2013 was implemented, what were their highlights? What did they highlight? What are the main points? Let us see. The Companies Act 2013 is an important law that regulates the formation, management and functioning of companies in India. The major highlights are means how the formation will be, how the company will be managed, how it is going to function, what are the rules, responsibilities, everything. It was implemented. The first one is incorporation of companies. Incorporation means officially registering and formation of a company as per separate legal entity. Incorporation means registering the company and the formation of a company. It is a separate legal entity. And let us see the points. Highlights of incorporation of companies. First one is in incorporation of one person company has been permitted by the Companies Act 2013. One person can form a private limited company. So when the act was formed, first they gave a right to one person company. uh, One person company, in according to the act of 1957, one person company was not there, but in 2013 this act was implemented, so that a single person also can start a company. It will be a private limited company. Second point is the limit of members in private limited company was 50. Companies Act 2013 implemented numbers of permissible members in private limited company raised up to 200. According to the Act of 1956, there were only 50 members eligible for private limited company. But when the new act was formed in 2013, it also implemented that number of members in a private limited company can be up to 200. The third point is the maximum number of people who can form an association partnership without registering it as a company is increased to 100 members. First it was only 50 members, but Companies Act 2013 increased it to 100. The means the partnership of registering a company, the partners who are getting merged together to form a company, registration was increased. Only first it was 100 members should only there in the partnership of a company. Then uh, sorry, it was only 50 members, then again it was raised to 100 member. Let us see the next point. Highlights of incorporation of companies. One more point is there. The object clause, clause means section of memorandum of association, does not need to be divided into separate categories like objects. Ancillary objects means supporting and other objects. The company can simply state the main purpose or activities for which it is formed in a clear manner. Before, why the company is formed, for what purpose, what are their objectives, what they are doing, everything need to be noted, everything is need to be informed. But under the memorandum of association, according to the act of 2013, the company can simply state the main purpose. What is the main purpose, what are the activities they are going to do, it should be cleared. Then next let us see second point. First one is incorporation of companies, second one is share capital and debentures. Let us see what do you mean by share capital and debentures. Share capital is the money raised by the company by issuing share to its members or shareholders. The money is raised from somewhere, however the company will raise the money to issue to its members. What are debentures? Debentures are a loan taken by a company, raised by the taken by a company from the investors or public. The company promised to pay interest. Debenture is a loan taken by company. It can take by a bank, however it is their choice, from or else from the investors or the public. Then the company, when they will return this, they should pay some amount of interest to it. Next, let us see the highlights of share capital and debentures. Shares other than sweet equity. Sweet equity means reward which is given to the shareholders or members of the company. Uh, Cannot be issued at discount. Other than sweet equity shares, other shares whichever the company is going to issue, that cannot be given on discount. Reduction of capital, share capital means reducing the amount of share capital of a company. It can be done only after getting the approval from the National Company Law Tribunal, NCLT. Means reduction of share capital means the amount which is reduced to share capital. It can be done only after getting the, if the National Company Law Tribunal will give the approval, then only the reduction of share is done. Third point is a company must appoint a debenture trustee when it invites more than 500 people to invest in its debentures. Debentures trustee should look after and protect the interest of debenture holders. Means a company should appoint a debenture trustee, means a person to whom they will trust to the debentures, how it is coming, how it is going. They will appoint a person as a debenture trustee. When it and when the trustee is inviting more than 500 people to invest in its debenture trustee, and the main responsibility of a debenture trustee is to look after whatever it is going on in the business and protect the interest of debenture holders. And they should not do any fraud. They should always protect the interest, and they should never mistake in anything. Let us see the third point. Third point is acceptance of deposit. Acceptance of deposit means a company receiving money from the public or its members as a deposit with the promise to return the money after a specific period of time along with interest if applicable. Means the company is receiving the money from the publics or its members, means like shareholders, stakeholders, investors, whoever, from whom they are collecting the money, receiving the money. The company will promise the person or the members to return the money. They will return the money in specific period of time along with some interest if applicable. Under the Companies Act 2013, companies can accept deposit only by following prescribed rules and conditions. Obviously there will be some rules and conditions. The company will accept the deposits. And the second point is a company that accepts deposits must provide insurance security for the depositors as required by the rules. This help protect depositors' money in case the company is unable to repay it. Here means a company will it is taking a deposit and they should provide insurance. If a person is going to invest, he should have some of the security, right? So the company will provide insurance for the deposit whoever is depositing their money to and the company's responsibility is to protect the depositors money if in case the company is unable to repay it. And the third point of acceptance of deposit is deposits can be secured and unsecured. Yes, obviously, as you learned last point, uh, they should protect the deposits. The company's responsibility is to protect the deposits. Here the deposits will be secured and unsecured. First, let us see what do you mean by secured deposit. The company keeps some of its asset as security for the deposit of the company. uh, fails to repay the deposit, the depositor can claim over those secured assets, or the companies will be having some of the assets. If the company is not able to pay the deposit at a time with some interest, the depositors who have deposited in the company, who have invested in the company, they can claim over those secured assets of the company. Unsecured deposit means the company does not give any particular asset as security for deposit. The depositor depends on the company's promise and liability to repay the money. In some cases, the company does not provide any particular asset or security to the depositors who will deposit the money. The depositors will depend on the companies. The company will be the company will promise the depositor that they will return, but in unsecured assets, the company will not provide any security and any assets to claim when the company is not able to pay the money. So the company promises an ability to repay the money. They will depend on the depositors will depend on the company itself to repay the money. Acceptance of deposit, this is the last point. Non-banking financial companies are not governed by Companies Act provision relating to acceptance of deposit. Instead, they follow the deposit acceptance rules made by RBI. Like the non-banking financial companies who don't have non-banking system are not governed by Companies Act. They are not governed by they does not follow the Companies Act 2013 and their provisions relating to acceptance of deposit. Instead, they follow the RBI system. RBI means Reserve Bank of India. They will follow the system of RBI. They does not follow the system of Companies Act 2013. So this is the third point. Let us move on to the fourth point: management and administration. The way a company is run, managed and controlled to achieve its objectives is it provides rules. The management means how the company is managed. Administration is who is controlling, who is running the company in a proper manner. And the first point is forms and certification. Obviously, when a company is coming into existence, they have to fulfill some of their uh, documents. They have to submit a form and they will receive a certificate after that. Let us see the point. Company has to submit certain forms and documents to the registrar of the company, and some of them must be certified by chartered accountant, company secretary. Yes, this when the company is for getting registered, it should be checked, it should be registered by chartered accountants and company secretary. Let us see what are the points under the forms and certification. That is the first point, and this is the second point. For all the companies except 1% companies and small companies with prescribed paid up capital and turnover, whether private or public, listed or unlisted, annual return has to be, here the spelling I is a mistake. Here it should come annual return has to be signed by a company secretary. Except the small companies and 1% company, their paid up capital and turnover is for themselves itself. They are the it is run by in a small quantity, but private or public, listed or unlisted, what are the annual returns, what is the turnover of the company has to be signed by a company secretary. E-governance proposed for various companies process like maintenance and inspection of documents in electoral form, option of keeping books of accounts in electoral form online. E-governance means when a company is process its maintenance and inspection of documents, when the company is checking their maintenance and inspection of documents, it should be done in an electronic form. Electronic form means online. Option of keeping books of accounts in, and even the books of accounts whatever they are maintaining of a company, it should be in an electronic form means online. Second one is meetings. One one person company is not required to hold any annual general meeting. Obviously in a one person company only, it is run by a one person, so there is no need to prepare annual report to show to the shareholders or board of directors. So a one person company is not required to hold any annual general meeting. Second point is notice of annual general meeting should be sent to all the directors of the company. If it is a big company, private, public, listed, unlisted, whichever the company it is, they have to, when the annual meeting is done, they should send the notice to all the directors or the shareholders, investors. They have to send a notice to them for the annual general meeting. Next point is for special business to be transacted in general meeting, explanation should be given with specific statement and specific information. If there someone is generating a special business, it should be transacted means general, why it is done in the general meeting, explanation should be given why it is done, why you are doing this, what reasons, questions will be arising, so the it should be cleared, and the specific statement they should provide about the specific information, why it is going to happen, why it is a separate special business to be transacted. And next point is company should follow secretarial standard. Obviously the company secretary, what are their standards, they should company should follow according to them. Next is under management and administration. Third point is secretarial audit. What do you mean by secretarial audit? Let us see. Secretarial audit means an independent verification of company's compliance with applicable laws, rules, regulation, and secretarial standard. It is conducted by company secretary in practice. Why secretarial audit is done means it is an independent verification of company, whether the company is there, not there. A verification is done. Here the laws, rules, regulations, everything is done, and secretarial standard, it is conducted by a company secretary. There will be a company secretary, it is done by that person. If the company secretary finds out any mistakes or non-compliance in the secretarial audit report, the board of directors must give an explanation to those points in the board's report. In case if the company secretary is finding any mistakes, any fraud, and anything he is going to find, it means the board of directors will be responsible for it, and the company secretary will raise questions against them. And the board of directors should explain what, why it is done, why the mistake has arisen, why the fraud is done, everything the board of directors should report. And the next point is the company must include the company secretary's audit report with the board's report and submit it to the shareholders. Obviously a company will prepare a report, audit report, annual audit report. Along with that, the company secretary audit report should also be included when the reports are going to submit to the shareholders of the company. Next, last point is annual documents. What do you mean by annual documents? Let us see. Annual documents are the most important documents that a company prepares and submits every year to show its financial position, performance, and activities. Annual documents, as you know, it is an important document. It is prepared to show the financial position of the company. The requirement of separate compliance certificate has been removed. Instead, the annual return now contains more detailed information about the company. Means, first there were separate documents were prepared, separate certificates were prepared to show that annual position of the company, but according to the act of 2013 it was removed. Instead of that, the annual report now contains more detailed information. In the annual report, all the information, position, financial condition, everything will be included. So the annual return now contains more detailed information about the company. The next point is the annual return filed by a company or by a company having such paid up capital and turnover as may be prescribed shall be certified by a company's secretary. Means the annual returns filed by a company or by a company which is having paid up capital and turnovers, it should be certified. Everything, the documents should be certified by the company's secretary. Thank you students. If you have any other doubts, you can comment me. If you need any more topic, any more questions, you can just comment me. I'll go prepare a answer for that. Thank you.